Good afternoon, folks, and welcome to the webinar today. Today, we will be talking about what to do with abandoned personal property in a commercial unit. My name is Eli Gordon. I am a partner with the law firm Kimball, Tyree, and St. John. Kimball's, Tyree, and St. John, just a little bit about the firm. We've been representing landlords for over 40 years. We have a statewide practice. Our firm assists owners and management companies in all areas of their business. This includes landlord-tenant matters and evictions, fair housing defense, employment concerns, and also estate planning. We try to focus on preventative law here at KTS to try to reduce your legal problems and avoid potential lawsuits. We have a host of training and other online seminars that are available. Our flagship and most popular trainings involve fair housing, landlord-tenant law, and also sexual harassment prevention. Be sure to visit our website, which is www.kts-law.com for more information. At the website, you can get additional information on trainings, webinars, and also sign up for our legal alerts directly on the website as well. A quick legal disclaimer that I'm required to read. The seminar offers general information only. It's not intended as legal advice. Attendance at this training does not create an attorney-client relationship. For legal advice on specific issues, feel free to simply contact me directly. The information contained in this webinar, this training, may not be duplicated in any way or duplicated in any other medium without Kimball, Tyree, and St. John's prior written consent. So what are we going to be covering here today? We're going to be covering primarily Civil Code Section 1993 and the following statutes. We're going to cover the safe harbor process that's spelled out in Civil Code 1993. We're going to talk about what you should do with business records that are left at the property. And we're also going to talk about what to do with vehicles that are abandoned or that are still parked at the property, although you evicted that tenant several months ago, or several weeks ago, several days ago, just depending upon the situation. So Section 1993 provides what we call in the law safe harbor. And in general, a safe harbor is simply a statutory procedure which, if it's followed, insulates the person from liability, in this case, the landlord. And the liability we're talking about in this situation has to do with liability for wrongful disposition of personal property. Common tort, which would deal with this, would be conversion, the tort of conversion, or trespass to chattels. If a wrongful disposition of personal property could potentially also be a breach of the lease, just depending upon what your lease says. Or it could just be simply a general negligence claim, failure to adhere to the standard of care for abandoned property. So what 1993 does is essentially is your get out of jail free card, so long as the provisions are followed. It's important to note that this process that's set forth in 1993 is not a requirement. It's not mandatory that a landlord undertake to do the steps in this process. What a landlord is charged with is simply using any reasonable means to dispose of abandoned property. What this code section does allow and does provide is this safe harbor, which I explained, and it insulates the landlord from liability in case of a wrongful disposition of property. Forgot to mention at the jump, I believe there's a chat box or something where you can ask questions. You may ask some questions in there, but I'm not able to actually access that at the moment. Little technological glitch on my end. So if you do have questions following the presentation, just feel free to email me directly. Okay. All right, so moving along here. So what are the basic steps in Section 1993? As a starting point, you always want to read the lease. Take a look at what the lease says to determine if there's any specific provisions as they relate to disposition of personal property. Most leases that I've seen, it's going to say something along the lines, the tenant simply needs to remove all personal property when they vacate, or it may say that any personal property left behind may simply be disposed of in any manner that the landlord deems fit. And those provisions are fine provisions. There's nothing wrong with those, but they don't provide a safe harbor. So if you follow what's set forth in your lease, you could still be sued. You can, in fact, still be sued if you follow the procedure in 1993. Nothing stops anyone from suing anyone for anything, in fact. But what this does provide is a defense. This would be a defense to any kind of lawsuit for wrongful disposition of personal property. So let's get to the process. It starts with a written notice. It is a written notice. It's essentially a form that you would fill out. You'd keep the form, fill it out in the specific situation you're dealing with. And there is some information you would need to input, certainly, which we'll go over. This isn't simply a check the box as to the notice. It does require a bit of thought, a bit of consideration. The code requires the landlord to serve the notice on the former tenant and also anyone else that they reasonably believe has an ownership interest in the property. The notice must state that they can retrieve this personal property within 18 days. 18 days from the date the notice is mailed, or if the notice is hand delivered, for instance, you just hand it to your tenant, then the time period is just 15 days. If the property is not retrieved within the prescribed time frame, depending upon the value of the property left behind, the landlord may either hold a public auction or they may dispose of it in any manner that they deem fit. If the tenant or owner claims the property within that prescribed time frame, again, either that 18-day or 15-day time frame, depending on how it's served, the landlord can then condition return of the personal property on receipt of reasonable storage costs. What are reasonable storage costs? Well, what we typically advise is to take the rent divided by 30, count the number of days that are at issue. Those are your reasonable storage costs. It's a reasonable way to determine what kind of value the storage of the property has. It's important to note that you can't simply hold the property and demand all the back rent that's owed. You can't demand future rent. All that you can demand is the storage costs that I described. So another important step of the process, the first step of the process is simply to describe the property. Take an inventory of what property was abandoned. The more detailed, the better, really. The landlord is only going to be shielded from liability for listed items, but there is no requirement that the landlord have X-ray vision. If the property is in a safe, some other type of secured container, you're not required to break open the container, crack the safe. You can just simply list the container or list the safe on the notice itself. This could, it could create some issues with respect to how detailed you want to be. Generally, we say try to be as detailed as you can. But if you're describing records, if you find yourself describing every paperclip and things of that nature, you're probably being a bit too detailed. So certainly err on the side of being descriptive, but being general in nature when you're dealing with a large number of kind of small or same type of items is fine as well. Another important step in the process, perhaps the most important step, is to assess the total value of the personal property. And the value of the property is essentially going to determine what you can do with the property. The law says you need to do. If the property is worth less than $2,500 or an amount equal to 1 month's rent, whichever is greater, the property may be kept, sold, or destroyed if the former tenant fails to reclaim it within that 18-day period. So under this example, if rent is $10,000 and the property is worth less than that, then it may be kept, sold, destroyed, disposed of in any manner you deem fit. However, if the abandoned property is worth an amount equal to or more than $2,500 or 1 month's rent, whichever is greater, then the property must be sold through a public auction process. So again, with the same example, say rent is $10,000. If the property at issue is worth more than $10,000, then you need to go through that public auction process. To avoid potential liability for conversion, it's important you kind of get these figures accurate to the best of your ability. And to do that, when you don't know the actual value of the property, it's best just to estimate a value from an auctioneer. Get an estimate from someone that has some form of expertise in appraising property, an appraiser, auctioneer, some other knowledgeable person. Conservative landlords will simply auction the property if it's kind of a close call. You know, there are situations where you go into the unit and it's just it's obvious it's a bunch of trash, it's a bunch of boxes, perhaps leftover dishes and things like that. You know, in situations like that, it's likely not going to eclipse the threshold there. But whenever it's kind of close, it's best to get an appraisal and simply have the property auctioned off. And we do recommend that you simply hire an auctioneer when you do have a situation where you have to hold an auction. There's certain notice requirements for auctions, and the auctioneer is going to know those notice requirements as far as publishing and notifying the public of the actual auction itself. One practice pointer to be aware of when it comes to assessing the value of the property, again, the standard that we're looking at does refer to rent. So there needs to be a determination of what rent is. And with commercial leases, as you may know, it sometimes can be difficult to determine what's actual rent. You have your base rent, you have your additional rent, you have your CAMs. So you need to kind of make an evaluation of what the rent is. That's not always an easy type of process. Most conservative approach would just be to utilize base rent. It's kind of the lowest figure, it's the lowest threshold. But if a lease has additional rents that are set forth in the lease, and for instance, your lease defines, which many leases do, defines all charges due under the lease as rent, then a reasonable argument can be made that that is the figure that you need to be dealing with when making this inquiry. Any doubts in this regard, you should simply contact and consult with legal counsel. Okay, so you have this notice, you've described the property at issue. Who do you serve it to? You've assessed the value. Who do you serve it? You serve it on the former tenant or tenants, and you also must serve it on everyone that you have a reasonable belief may have an ownership interest in the property. Now, this reasonable belief standard is something that's very common in the law. You'll often see this reasonable belief, reasonable person standard frequently come up in the law. And so what is a reasonable belief in this context? It's generally the actual knowledge or belief a prudent person would have without having to make an investigation. This does not mean that we can simply put our head in the sand when we're confronted with information, or we have specific information that indicates that some third party may have an ownership interest or security interest in the property at issue. For instance, we typically advise landlords to inspect the property itself, the actual personal property, determine if there's any stickers on it or any indication that there's another owner out there or some lien holder, for instance, a furniture rental company or a large equipment seller who maybe retains some form of a security interest in the actual personal property. Perhaps some of the appliances or other larger items of equipment have been financed. And so if you're faced with kind of those stickers or those things that are affixed to the property that state the name of some third party, you may want to reach out to those third parties, determine if they have any ownership interest in this property. And in fact, you're likely required to do that. And when you have any doubt, you should simply serve them with an abandonment notice. And if you serve them with that abandonment notice, you also are protected from liability as against those third parties as well. So although you don't have a really high standard to deal with when you're talking about a reasonable investigation, you do need to just pay attention to certain kind of obvious demarcations on the property itself or otherwise indicating that some other third party may have an interest in this property. And those parties should be noticed as well. So one item of personal property that can sometimes cause confusion is what to do with business records. Business records with private customer information such as medical records or financial records are sometimes abandoned, left over. Until recently, the landlord's obligations regarding these business records were not entirely clear. Should the landlord just try to contact these people whose records they appear to be? Should they destroy them, auction them off? Now California law has updated the provisions in this regard and provides that the tenant is presumed to be the owner of these business records. Therefore, these abandoned business records should simply be listed as abandoned business records or business records on the notice of abandonment itself. Excuse me, you don't need to describe every piece of paper or every form or binder that's left behind. You can simply describe the abandoned property as business records. The law defines business records extremely broadly. It's defined as any material, regardless of the physical form, on which information is recorded or preserved by any means, including in written or spoken words, graphically depicted, printed, or electronically transmitted. If the tenant doesn't claim the business records containing this private information, the landlord must just destroy the records in a secure manner. So in other words, when it comes to business records, those should not be included in the auction process. To the extent it's avoidable, do not include business records, simply just destroy the records. So what's the process for vehicles? And what should you do if the item of abandoned personal property includes a vehicle. Now, there's a vehicle code which would apply in this situation. And in certain situations, a landlord can tow a vehicle that's located on private property. You should contact a towing company. If the vehicle owner does not claim the property, and the towing company can sell it to satisfy the towing and storage costs. And you should always be sure to certainly utilize a licensed towing company for this process. Now, there's 4 situations that are set forth in the vehicle code where a vehicle can be towed. And this is where they can be towed from private property. And the first is a sign. This is a sign that's a specific sign that needs to be a certain size. It needs to state certain specific things. And the sign should be posted at each entrance indicating that public parking is prohibited. The second situation is a parking situation parking citation that is, has been issued and 96 hours have elapsed. And the third situation is the vehicle is non-operational. Local law enforcement has been notified. 24 hours have passed. And the fourth situation is the vehicle is parked on a parcel that's been improved with a single family residence. So if someone parks on your property and there's a single family residence on that property, they can simply be towed. Now, the obligation is the landlord when there's been a tow simply to notify the local traffic enforcement within 1 hour after authorizing that tow. The tow truck operator also has several duties, which we won't get into here. Now, one topic I don't have a slide on here today, but I do want to mention briefly is that in general, fixtures are items which are permanently attached to real property. These are things like water heaters, central air conditioning units, sinks, and built-in furniture. So the concept of a fixture. Whether an item should be removed by the tenant upon vacating or not depends on what your lease says, and it also depends on what the law of fixtures says. This can be a kind of a technical exercise. It can be a very case-specific type of inquiry, which is really just beyond the scope of today's presentation. But if you have an issue or a question that relates to fixtures, happy to chat about it offline. Another thing I should mention is that this year, the process for declaring the real property, in other words, the commercial space itself, abandoned, has been updated. Previously, the landlord had to wait 15 days, and rent had to be delinquent for those 15 days. And also, the landlord had to have some reasonable belief that the premises were abandoned. And those were prerequisites to actually serving a notice of abandonment of real property. And those are it's a very similar type of notice to the notice we covered today dealing with personal property. So the law was recently updated with respect to abandoned real property to now allow for the landlord to serve this abandonment of real property notice within just at least the number of days that rent would normally have been due. So for instance, but not before the 3rd day. So for instance, if rent is due on the 1st of the month, and you have some reasonable belief that the space itself has been abandoned, then you may serve a notice of abandonment on after the 3rd of the month, so after 3 days. And that could potentially speed up the process to take back abandoned real property. Again, it's kind of a similar notice type of provision. If you have questions on that or would like further information with respect to abandoned real property, just feel free to contact me directly. And that concludes our presentation today. Again, if you have any questions or concerns or would like to chat about any kind of specific issue that you have, please email me. If you missed it, I'm not able to access this chat box that is apparently in the webinar tool there. So, but happy to answer any questions you have. My email is eli.gordon@kts-law.com. And thank you very much for your time today.